Yes, sorry about that. Mr. Hopkins, you've got a few more minutes.
I'm grateful, my lord. You were asking me about why the Chapter 5 issue was not in my submission something that was integral to or went to the heart of the public law decision. Chapter 5, of course, is the issue that comes the closest to that threshold.
Yes.
But I say nevertheless it doesn't. And by way of shorthand or shortcuts, I'm not going to try to improve on, but will instead refer you to the key paragraphs of the Divisional Court's explanation, if I may.
Yes, certainly. Just give me one moment. Remind me where they are.
So, if you have that judgment, paragraph 139.
Yes.
We'll pick things up there. And the way I summarise this section of the Divisional Court's account of its reasoning, that runs from 139 to 142, is as follows. First, paragraph 139 is the Divisional Court saying that as a matter of fact, decisions taken under the immigration rules are not contingent on, do not take into account or base themselves on suitability of data transfers. So that's the fact point the Divisional Court makes. Second point is that as a matter of law, the same conclusion follows. And at paragraph 140...
Well, I'm sorry, I read the structure of this slightly differently, but maybe wrongly, that 139 was concerned with inadmissibility decisions, and 140 onwards was concerned with removal decisions.
Yes, well, perhaps I'm applying labels. That one doesn't.
I see. Right, sorry.
Things, but the point, the substantive point, is that 139 and then 140 is the Divisional Court's analysis of why the immigration rules why nothing in those rules points to any support for Mr. Gill's submission that compliance with data protection provisions is a condition precedent. And I say the Divisional Court is right about what it says about the immigration rules 139, 140. Just skipping to 142 for a moment, the same conclusion is reached if one looks at the other piece of the legal jigsaw, moving from the immigration rules to the data protection framework. To sum up the points made at 142, the Divisional Court says, and I say with respect rightly, that nothing in the GDPR or the Data Protection Act 2018 provides that past transactions which have relied on data processed in breach of data protection law are to be undone, or for that reason treated as void. That's a quote from...
No, well, clearly they don't, but can that be a complete answer? Find it difficult to imagine, but imagine a public law decision, or try and keep it in this area, a removal decision, of which it was a central part, that a great swathe of personal data would have to go, it wouldn't be operative unless a great swathe of personal data, maybe health data or family data, had to be passed to the country to which someone was going to be moved. It wouldn't be realistic to say, well, that's not necessary under the rules. You'd still say, well, it is necessary. This particular decision would not have been taken and could not have been implemented without this great swathe of transfer of personal data in breach of the rules. Now, wouldn't that invalidate the decision?
I accept that, and I used the language of tail-wagging dog earlier in my submissions. I accept that there will be cases in which the data issue is more dog than tail, and in fact that is what the Divisional Court itself recognises.
Yes, I see.
See paragraph 141, it's right in the middle of the sandwich of legal analysis that I've just been referring to, my lord. 141 is an express recognition by the Divisional Court, fairly and rightly, that there will be cases. It is possible to conceive of cases.
Yes, I see.
Where the data issue is so integral to the, if you like, substantive public law issue, that contravention of the data protection provisions undoes things. So I'm not making a submission. That's
No, okay, I've got the point. I've hurried people up occasionally on the other side. I hurry you up. I've got that point.
That's what I wanted to say, unless I can assist you further on that,
Yes.
that point where you left us before that short break as to why the Chapter 5 issue, which it has the best chance.
Yes, well, I think we all accept that. But if you're right on that, then you're right on the other two.
Yes, that's my setting.
That's yes, and it doesn't really help you to be right on the first two unless you're right on this one as well. Well, but if you were right on the first two, that's to say Article 35 and Article 13, but wrong on this one that it was integral, then you've got to say, well, it wasn't unlawful, and that's 49(1)(d).
Yes.
Headline points on that, I think I've got them, but just your headline points.
First headline point is that it was plainly open to the Secretary of State to rely on Article 49(1)(d), and it is unarguable to suggest otherwise. Specifically, it's unarguable to suggest that the Secretary of State was required to put regulations before Parliament. That simply...
Sorry, was required to do what?
Was required to put regulations before Parliament.
Yes, I see.
And this is a point on one of Mr. Gill's points.
Well, it wasn't one of the ones he emphasised just now, but yes.
That's unarguable. So in principle, 49(1)(d) is plainly available in circumstances like this. Second headline point is that 49(1)(d) is not only available but satisfied because the transfers at issue here were necessary for a reason of, and here's the key phrase, substantial public interest.
Well, it's got to be substantial public interest recognised by law.
Recognised by law, but it does not have to be statute. And it does not.
Is there a difference in recognised by law and incorporated in a law?
I say that recognised by law can extend to recognition by the common law. Paragraph 145 is where the Divisional Court makes exactly that point, that the courts have recognised the substantial public interest in the carrying out of duties and the making of decisions under the immigration rules. My next headline point is that the transfers at issue in this case are reasonable and proportionate. That's what the Divisional Court says. It's paragraph 145. Now, two limbs to that. One is it's back to my tail wagging dog, or if you're going to transfer the human, you need to transfer a certain amount of data about them. So the data transfer is plainly necessary if a decision about an individual is to be implemented. And then the concluding point, and this goes to the proportionality of these transfers and why I say Article 49(1)(d) was satisfied in this case, goes to Mr. Gill's significant focus on what he says were inadequate safeguards.
Yes.
Things that might happen to data once it
Well,
gets
that's what
to
I was going to ask you, yeah.
For your note, paragraph 127 of the Divisional Court's judgment is where it notes the key provisions of the MOU that commit governments of Rwanda to dealing with personal data of transferees in specific ways. And I commend, with respect, also paragraph 148 of the Divisional Court's judgment. And that is where it gives a very short, but I say correct answer to a point of which Mr. Gill is very fond, but which I say is a great distraction, which is the Schrems Facebook litigation.
Mm-hmm.
It is nothing like this case. I don't propose at this time of day to get into Schrems in any detail, but that was a case about whole-scale transfer of anything by any Facebook user in the world into the United States, metadata and content data of their communications. That was what the CJU was looking at. That's the scale of the exercise. And little wonder that in that context, the CJU says, well, if we're looking at such bulk transfers into the United States, where a host of
I got the point, yeah.
That is nothing like the constrained nature of the transfer in this case. So Schrems is of no assistance. That was the last point I wanted to make, unless I could assist further.
No, thank you. That's been very helpful. Mr. Gill, I think I should give you the last word, but I hope you will, well, I know you will not abuse it by making points you've made already.
My Lord, so far as the point about 145 is concerned, all that says is there's recognition in the public interest in removal of persons. That says nothing about the public interest in the removal of data.
What about removal of persons necessarily means transfer of some data?
No, you can't do that, because that's not what Article 49.1d and 49.4 says, and that is not how Section 13 is framed. Section 13 specifically talks about the public interest in the transfer of data for that very reason, puts it into law.
Thank you.
So far as the point about they're desperate to get away from Schrems, because once one gets into it, they're going to be sunk. The point is that it is not about the scale. The issue about Schrems is it was the possibility that the US security agencies might have access to that data in ways about which someone could not do anything. That's the point.
Yeah.
And we are saying, same reasoning applies in relation to Rwanda, which is why the last point about Para 127 that was just made doesn't work, because Para 127 relies on assurances, gets us back into Ottoman territory. Assurances are not going to be good enough here. See Schrems. They want legally enforceable standards. And I mean, I could go on, but frankly, this point is far too huge for it to be dealt with on the basis of what is, with respect to short skeleton argument.
Not on your side.
Well, it's 22 pages, but but I'm not sure that there has been actually opportunity for this court to actually.
No, well, that's a fair point. You would say it's a big point, and it's not a point for to be knocked out at the permission stage.
Yeah, and
of course I do.
The Supreme Court itself recognised the importance in relation, and that was, I think, a removal case, in relation to that any interference with data protection has got to be strictly necessary. They've got to show that. So far as the Article 13, the Chapter 3 points are concerned, as I've been hanging on all the time, including in the jail grounds, the asylum aid submissions about lack of notice form the starting point of my submission on that. But I'm even stronger than that, because we have, and Lord Justice has made this point to me himself, that you actually have a statutory duty to a right of notice, don't you? We do. And that's
statutory duty to do what?
To a right of notice, to be given the notice.
Yeah.
And that notice that your data has been collected and it's going to be used for such and such purposes, the purposes must be something about which I've been notified. And we haven't been notified about that. And this is also relevant, I think, in one of the submissions in the AAA or the AA cases. So that is why I always make the point, I'm going to need their evidence, and I'm going to make the submissions on why these risks arise, why I haven't had adequate notice, why these risks arise, and why you've got to go through the Article 35 Data Protection Impact Assessment to deal with the risks in Rwanda. If you want just, there is a bundle of materials that has been put forward to you.
Why am I going to want that bundle of materials?
I don't want you to go through it, but
I put together for myself a much shorter bundle, which contained all the statutory provisions and the head notes of all the.
I won't bother your lordship with it. I won't bother.
If you want me to have it, I'll have it.
No,
but
no,
I do feel I've got enough.
No,
if you rightly remind me, this is a permission stage.
My lord, let me leave that. I'm conscious of the time as well. But there is a bundle, a supplementary bundle, a different bundle of evidence In there is Mr. McGinley's statement. He's the person who was responsible for this. If you were simply to look at the pages 319, 415, 423,
319,
415, 423 of that bundle, these are exhibits to Mr. McGinley's statement, where their own data protection officer says, I'm very uncomfortable with the fact that there are all these risks, and we aren't dealing with them, and I'm very uncomfortable with 49.1D. McGinley disagrees. Nobody does anything about it.
Okay. Thank you very much indeed. Now, Mr. Ahmed, we have two outstanding grounds in your case. Ground C, which is a procedural fairness point. Sorry, I started talking before I'd even got your bundle out. Here we are. And ground D, which is effectively Tameside. So far as Tameside is concerned, that's a point being taken in AAA. Hasn't got permission yet. You'll have to wait and see whether it does. If it does get permission, you don't need it for the reasons we've explored. If you but as to the question of whether it should get permission, you have the right to be heard in addition to anything Mr. Hussain had to say, but maybe you'll feel you don't need to say more than Mr. Hussain.
Well, I don't think I need to. I think Mr. Hussain put the points quite eloquently, so I don't think I need to.
No, that's what I expected you to say, and I'm sure is right. Now, as to ground C, sorry, I've been thinking so much about data protection. I just want to remind myself. Yes, that. Well, you see what I've said in my order at paragraph 8. These are, if you're making particular points about the facts of your case, what decision are you challenging?
My Lord, I can deal with point C, and having read the observations made by the court, it's right that we were stayed in respect of the NRM claim. That's the modern slavery claim. That was the part of our claim which was stayed, and I plainly take on board the observations of the court, because the decision that we seek to challenge is the generic, use the sort of term loosely, the generic inadmissibility decision. It didn't focus upon the positive
yes,
reasonable grounds decision, which had been promulgated by the time Secretary of State came around to make that decision.
Right. Well, again, that seems realistic. But if that's so, again, really, it's the same as for Tameside. Between them, the other parties are taking, I think, all the procedural points that you want to take. Asylum aid and
yes,
others.
Absolutely. And I'm content for that. I think the point that was being taken against me by Mr. Sheldon was, firstly, it didn't form a part of our pleaded case. Now, I don't know whether that troubles my Lord. If it does, I can address my Lord in respect of that by taking you to the grounds of appeal and then the skeleton argument, where effectively we adopted the generic submissions which were made by the other claimants. And we did that because the Divisional Court was quite passionate about parties not repeating or repetitive. And in fact, one of the concluding remarks within the skeleton argument, which was settled for the hearing in September, was, for the purpose of brevity, we don't repeat the submissions.
Yes.
And that wasn't the point which was taken against me when I addressed the Divisional Court orally in the 5th of September hearing. But it was there, it was before the court. Now, I think what I was going to add to that is, and I can see why my Lord gets to the observation my Lord does in the decision for appeal, and reference was taken to paragraph 42. Now, I'm sorry, 43 of the consequential judgment of the division.
Not by me, it wasn't, or perhaps it was. if we're looking at the same thing. But anyway, keep going.
Yeah, so I think the short point I was going to make was this, that the divisional court, in fact, I was in counsel on that occasion. Counsel on that occasion simply just adopted the grounds that were being advanced by AAA. He did.
Yeah, but I wonder whether we're making this too complicated. What I think, well, the position I thought we were going to come out at is that both as to ground C and as to ground D, and there's no criticism of anyone, I see exactly how it happened. You are not taking any point that is not already covered by the generic grounds. But of course, if the generic grounds succeed, you are entitled to the benefit of them,
yes,
insofar as they apply to your case. That being so, although I think formally you could ask for permission to appeal so as to be in court as a party, you wouldn't be encouraged to say anything, because we will be just as strict as the divisional court about one lot of counsel per submissions. And what I'm minded to do is to refuse permission, making it clear, which Mr. Sheldon has confirmed, that whether you are a party to the appeal or not, whether indeed you're a party to the proceedings or not, but insofar as any of the generic grounds succeed, all parties to whom they apply will get the benefit of them.
Could I? Yes.
Yes, because I mean, otherwise, if I gave you permission saying, well, ground C and ground D are arguable grounds, I suppose I said they are, but they're just the same as the other people's grounds, so you can turn up and just sit there. What's achieved?
My lord, could I make 2 points in respect of that? I think the first point that I make is this, that we are a party who would be affected by the outcome. That's
yes.
The first point. I think the second point is the right to be joined. In respect of it, if it was a joinder application, it would be an application being made to the court, and know that the court is familiar with the authorities. It's set out in CPR 52(1)D, the right of even a non-party.
Yes.
To, and I think if the court was to perhaps approach the matter even within that prism, we're in fact a far better position in the sense that we've made the arguments.
Yeah.
We've adopted the arguments. I think the criticism is that we didn't make those arguments specifically ourselves, and that was simply for the purpose of brevity, not to be repetitive.
No, I've got the point, but it really just comes down to this: you are saying that whether or not you are going to be allowed actually to address the court, these are points that you took below, and have, here they are, grounds C and D taken in your grounds of appeal, and if I regard them as arguable, you're entitled to be there. Although you may have a very quiet time, or Mr. Metzer may.
Yes.
Well, Mr. Sheldon, that's formally correct, isn't it? It's not a position I encourage, but it's not something I can properly refuse.
Well, my lord, on the issue of passive adoption of other people's grounds, you've heard me already. I don't have any difficulty with that. It sounds as though the only issue is whether or not Mr. Metzer and or Mr. Ahmed sit in court or
well, yes, I mean, who knows? Something unexpected may come up, or they may think the crucial point has never been taken, but it's not very likely. No. But it seems to me that formally, a party who has gone to the trouble of pleading these grounds, knowing they're unlikely to get the chance to make a significant contribution, if they want to insist and someone will pay for them to be here, I don't think I can properly turn them away.
Yes, my lord. I think the Secretary of State's position would be that it shouldn't be her who pays for them to be here.
Well, that's another matter that we would. You can fight that if the situation arises. That point is noted. But very well. So I think this is where I've come out on this. Mr. Ahmed, if I am satisfied in the other cases, and I felt, well, I already am in C because that's effectively the asylum aid points. And if I'm satisfied on Tameside, I should give you permission, but you know, because I've told you now more than once, that unless something unexpected happens, you'll have a passive role at the hearing. and the Secretary of State may not want to pay your costs even if she loses.
Yes.
But that when we'll cross that bridge if we come to it. Very well. I think we've now got to the end of the individual cases. I have already said that because it's all taken probably no longer than I should have expected, but nevertheless longer than I hoped, that I'm not going to give you any decision now on which or any of these grounds I'm going to allow to be pursued. It will be a priority for me to consider my position tomorrow. Considering it and writing it up may well mean that you don't get a decision until a bit later in the week, but we'll have to see, but it's the next thing I'll do. Now, that then brings us to... sorry, you wanted to say something, Mr. Hussain?
I was going to say, my lord, I'm going to address you on timetabling.
Yes.
And I was just wondering, something that you floated in one of your directions, that you might give a decision on permission with reasons to follow.
Yes, I'm not going to do that either.
Sorry?
I'm not going to do that either. I've got some thoughts, but I've been caught out once or twice before. Until you've written them down, you're not quite sure they work. So I'm afraid we will have to have the next discussion on a slightly unsatisfactory basis, because certainly some of the points, not all of them, on which I'm being asked to give permission, would quite significantly increase the length of the hearing. The most obvious one is Mr. Gill's data protection points, though they would also be hivable off if that were really necessary. I'm not convinced that most of the others would make much of a difference to the estimate. But it'll have to be on a rather uncertain basis. Now, so I'm not going to do that. So where do we go? Do we want to talk about estimate first? It's Miss Dubinsky, I think, who no, it's not Miss Dubinsky. Was it you, Miss Dubinsky, who felt most strongly about... Someone has written to the court saying 3 days is far too short and it's monstrous.
It's asylum aid, my lord.
Sorry?
I'm Miss Gilroy, acting on behalf of asylum aid.
Oh, I'm so sorry.
Yes.
Forgive me, and I was looking at the wrong person, giving the wrong name. But well, I was looking at the right person, but the wrong name. Yes. Well, do you want to go first, and then I'll hear what everyone else says? But you were the ones who've written a letter, so you've probably got the right to address me first on it.
Mr. Hussain, I think would like to say something first.
Yes, very well. No, I don't mind who does it, but
we also wrote in.
Did you? Sorry.
Yes, saying that we would be addressing you.
Okay. Well,
but what I'd like to do, if I may, is just I outline there's some common ground that there is.
Yes.
Then come to the battleground.
I'll trust you. I do have to rise at 4:44.
Yes.
So, but I'm sure you will be quick.
The common ground is regarding timetabling of the skeletons on this side of the room, as it were. So that's myself, Mr. Drabble, Ms. Knight, Mr. Ahmed, Mr. Dubinsky, Mr. Sheldon. And what we have agreed between our subjects, of course, to your approval, is that we put our skeletons in by the 20th of March. The UNHCR put their submissions in by the 24th of March, and the Secretary of State puts her skeleton in by the 6th of April.
That sounds fine.
With
Thank you. Just say one thing about that. Clearly, the skeletons, in one sense, you won't know exactly what you're going to have to do till you know what the position is on permission. Having said that, of course, the people who sought permission have already done skeletons on that, so it's just be a bit of cutting and pasting. And
yes,
exactly. Or in your case, I think you just have to take out the bit saying permission sought, because you've done already a full skeleton.
yeah, and reflect in light of what my Lord will say.
Yes, quite. Okay, that's extremely helpful, and there seems nothing wrong with that. And bundles.
Bundles, you indicated 17th of April by noon. Of course, we will comply with that. Appeal bundles, authorities bundles. Could we please ask for a steer? I think you indicated you might give one as to how you want the appeal. bundles to be organised?
Yes,
That can be done
yes.
later.
Well, of course, one thing about bundles, I mean, it's up to you. You're all very experienced. But the old-fashioned way of doing the bundles after the skeletons and then doing the so-called replacement skeleton argument, which is actually just the skeleton argument with the references put in, is rather clunky. It would be better if it were possible, but you may tell me it's not possible, to do the skeletons, to have the bundles ready by the time the skeletons are finalised. But I appreciate that would effectively mean bundles having to be finalised by within a couple of weeks, which is not realistic.
Getting head shaking.
No, I can see that's not really okay. Well, we'll do it the usual way.
It's much better for the advocate, actually, what you suggested.
Well, I mean, if I can help you to, I can help you to this extent. If you push those forward by, I don't know how it works with Easter, but by a week, in order that you could work from already finalised bundles.
No, it's not going to work.
Okay, I'm not going to press it.
Thank you.
Right now. The bundles, well, I only had one really pretty obvious point. There ought to be a common bundle which has in it all the common material. So the judgment below, the MEDC with all its component parts, then the guidance, probably the SOP, even though the SOP may not be relied on in all the cases. But anyway, you can use your intelligence about that. The worst thing in the world would be to have to turn to a different bundle in each case.
We did that below, and I think it worked reasonably well.
I'm sure.
So,
then there will obviously have to be individual bundles for the individual cases, which will contain the material relevant to those cases.
Core authorities, supplementary authorities.
Well, I wasn't really got as far as authorities. I was talking about the supplemental. Well, not just the supplemental. I was talking about the pleadings in each case and so forth. It did occur to me whether I really needed in each case to have not only, which I think I do need, the statements of facts and grounds and the Secretary of State's defence, but whether I also needed the skeletons below. But the way cases tend to go, you never know when you may want to see how a case was put below. So I think that's prudent. I mean, they're all copied anyway. So I can't think of anything else that the rules say you have to have generally, but we could dispense with in this case. Can you?
I don't think so. There was some murmuring about the transcript. Would you like the transcripts?
No. Well, if people are going to make points on the transcripts.
Chronology?
Oh,
I think you'd like one.
I'm sure. I think I might need more than one chronology. I think there ought to be a chronology about the development of the Rwanda policy and when the various decisions were taken. I appreciate those are individual decisions, but they're mostly all taken at the same time. Yes. Individuals may want to have individual chronologies about their particular cases insofar as they have points that depend on them. What were we saying before chronologies? Transcripts.
Not unless a point to be made.
Unless a point's been made. No, I didn't even. Actually, I did know there were transcripts because I've been sent them in your case, I think. But I'm not interested in how the case was put below unless a point was taken about it.
Well, yeah. Of course.
You've got them if you need to have them. Yeah. Okay, but we don't want them routinely. Authorities, yes, of course. Be sensible about authorities. Don't just put in every case that might be relevant. Well, I don't need to say this. Be sensible about authorities, but we'll want obviously all the rules and the relevant statutory provisions. I'm relaxed about how they are in the bundle. The one thing I had the other day, which was the silliest bundle of authorities I've ever seen, was where the authorities were in alphabetical order. I do not want that. They should either be in strict chronological order, which is probably best, but if there are particular self-contained bits of the case, for example, if we were looking at data protection, I think that would probably make sense to have them in a self-contained bundle or part of the bundle. But broadly speaking, chronological is best.
Absolutely.
And you don't need to be told, always do the law reports if they're in the law report and all that. Can't think of anything else. When you're using tabs, use real tabs for the hard copies, not just notional tabs, because they are quicker at finding your way around. Make sure that the numbering on the hard copy bundles marries up with the electronic bundles. You may well have a hybrid court where some of us are using paper bundles and some of us are using electronic, and nothing is worse. I think people are alive to this now. In the early days, they were often 2 or 3 pages out because one counted the title page and one didn't. But look out for things like that. And could you please, on the back of the bundles, I've been intentionally complimentary about these bundles, but that is too small for anyone to read. You need a big thing saying the name of the bundle, and if it's a bundle which is one of 3, it's very useful to know what pages are in each one, so 1 to 450, so that you don't have to guess which bundle it's in. Sorry, this is all very trivial stuff, but it does actually make a difference.
I do it all myself when it's not done, but those instructions you noted it.
Right. Now, so that is timetabling up to the hearing, including bundles. Anything else on which you want to steer about that?
No, I think that's fine. And then, my lord, the battleground. So, hearing length.
Yes.
Everybody on this side of the room thinks, with the greatest respect, that 3 days is just simply not possible, I'm afraid. The Secretary of State also...
Persuade me. I know it's much longer below, but there were many more issues below.
Well, below we had 5 days. Miss Kilroy had 2. Mr. Gill had 1. I have taken the liberty of getting an idea of how long everybody is going to take, and even with Mr. Arnold and Mr. Metzer playing a passive role, the aggregate is it's double what you suggested.
You won't get 6 days.
I know, but I appreciate that. It's double. If I can tell you what the estimates are, Miss Kilroy, a day and a half, Mr. Gill.
How can Miss Kilroy possibly take a day?
I will let her.
Sorry, Miss Kilroy, but
Mr. Gill, she has her explanation, absolutely, and it's a matter for her to explain. Mr. Gill a day, Mr. Drabble 3 hours, Miss Knight 45 minutes to an hour and a half, subject to counting any chickens and making any assumptions. If I get leave on all my grounds, over a day. Mr. Sheldon a day, over a day. UNHCR an hour. It adds up to about 6 days. Secretary of State had suggested 4 days in December. She's now changed the position. Every interlocutory hearing in this case.
Was Secretary of State the only person who asked? I thought other people had said 4 days at first. Okay. Nobody else submitted themselves.
No. And every single interlocutory hearing in this case has taken about double the amount of time that the court thought, I'm afraid. So we would ask for at least, well...
you want 6 days. I tell you you're not going to get 6 days.
I know.
I will...
If you're...
I'm going to go away and think about it.
Yes.
But I'm not likely to be persuaded to say more than 4 days, and I really do not think, with modern advocacy, with a court that's pre-read, even though there are a lot of issues in this case, and as I say, I think Mr. Gills is the only one which will add significantly to the estimate that I had when we originally said 3 days. But I think you're going to have to be thinking about 4 days.
Can I just address you on that, and also on Plan B and Plan C?
Yes.
Very, very quickly. Just on that, the points aren't straightforward. Ilias, there's no domestic case law in Ilias whatsoever. The virus points are intricate, but we have or leave on already. The penalty point is very important. It requires looking at the travel.
But important doesn't mean it takes long to develop.
Difficult, and but please may I address my plan. Plan B was severance with the safety or Article 3 issues heard in April, where with the pure legal or purer legal issues heard at a different hearing, and they would then include our Ground 6, Article 31, our vires argument, not Section 2 vires, but the Schedule 3 vires parliamentary approval should have laid an instrument. Our fairness ground, where we adopted Ms. Kilroy, so asylum aid, Mr. Drabble's EU law point that he doesn't agree with this, and data protection. So that would be a plan B. A plan C would be if you extend it to 4 days with indulging us, but still with severance of data protection and fairness. I think
The most obvious thing to sever, though this will not make much difference on the points on which permission's already been granted, might, if I have to give permission on some other points, is for individual cases to be severed. I mean that, for example,
we've thought
I don't mean individual.
I know what you mean.
I don't mean individual whole cases, but individual issues.
I know what you mean.
So, Mr. Drabble's point about trafficking, though I suspect it's not going to take very long, but if I give permission on that, certainly can be heard. That's certainly peculiar to his case. I mean, it might raise 1 or 2 points that were of interest in other cases, but it's not a generic issue. And there are probably 1 or 2 others like that. But that may not make very much difference.
No,
it's severing off some of the generic
We've
points.
thought about that, and it's not going to work because in terms of time, you're not going to save very much time. 90% of the hearing time is taken up with generic issues. So if there's going to be severance, then what we would suggest is either of the options. So safety.
I think I'd rather than write all this down carefully, because it's got to be a little bit provisional until we know what the issues are. I would be grateful if you could.
I'll do that.
Could you do me a short note?
Yes.
Get it to me tomorrow,
Yes.
preferably as a joint note. But if there are different views, that's fine. They can be noted on the note as well.
And I think Miss Kilroy is very anxious to address you.
Yes, I'm sorry. I will. I'll give her a chance in a minute.
She needs to explain that she's in a peculiar position.
Yes.
Very unusual position. I obviously have an interest in my clients because I have ground 8 where we're adopting her. So I think that's it. So we'll do a kind of plan B, plan C note.
That would be that would be very helpful. Yes, Ms. Kilroy, I'm sorry if I sounded rude when I said you can't take a day and a half. But I was surprised. Because I haven't had to make decisions about it, I haven't focused very much on your skeleton arguments, but I see the general points being made. What you say? A day and a half for your submissions, or
No. The estimate is a day and a half for the entire systemic, procedural, and fairness case, so including the Secretary of State.
yes, I see. Oh well, right.
So not me on my feet for a day and a half.
Well, I'm sure that would be delightful, but I'm glad you're not insisting on that. I'm going to take a view on that, aren't I? I mean,
Yes.
but are there particular points you want me to be aware
Yes.
of?
There absolutely are. I mean, my lord, we are in a very different position to everyone else in this appeal, for the simple reason that the arguments that we advanced and the Secretary of State advanced in the pleadings and evidence below and in oral submissions were not the issues on which the court ultimately ruled. So the court ultimately ruled in its judgment on an issue of law which was not argued before it and on which only written submissions were made by the claimant and the linked claimants after the hearing. And what the court did not rule on either was the arguments that were before it. So in other words, it did not rule on the pleaded case. And that's important because you are going to have now all of those issues before you in the Court of Appeal. So in other words, the issues...
So despite your making all these, if I may say so, for all I know, entirely well justified, but these criticisms of the Divisional Court, they gave you permission on all these points, even
Yes.
though... How did you persuade them to do that?
Well, they gave us permission to challenge the arguments that they, or the reasoning that they had adopted on the issues which only arose when the Secretary of State reversed her position on the second day of the hearing at 1 p.m. So in other words, on the reversal of the position in law which had governed all the arguments...
Well, you don't have to persuade me now.
No,
About, we don't have to make debating points. But the answer is that they did give you permission to deal with points that they themselves had not dealt with.
Well, they gave us permission to deal with points that they had dealt with but without having heard oral adversarial
Yes, I
argument
see.
from
Okay.
both the parties.
Yes,
So in
I
other words, what you see in the skeleton argument on appeal is a set of arguments supported by authorities which were never addressed in the court below, because the issue did not arise until after I had made.
Yeah, okay, I've got
my
the point.
submission.
Okay, I've got the point. So this will be de novo stuff. We
Yes.
won't be able to say we'll take all this introductory stuff from the judgment because it's mostly not there.
It's mostly not there. They have given their reasons as to why they took the position that they did, but they have given those reasons without having heard the arguments that are now put in front of the Court of Appeal. So you will have to, and I will be taking you to, authorities that are not mentioned in the judgment because the court did not consider them, argument that was not canvassed between the parties, and furthermore, in a situation where the Secretary of State has not set out her position at all. There is no pleading from the Secretary of State at all on this, either below or here.
You don't.
Yes.
I've got
Well,
the
I
point.
won't repeat that again, but it goes further than that, my lord, because the Secretary of State has, by way of respondent's notice, put before the court also.
I don't think I've seen the respondent's notice because I haven't got a bundle in. But it doesn't
You
matter.
should have a bundle in the asylum aid case. There is a separate bundle.
But if I have, I haven't brought it.
Ah.
That may be because I didn't think I needed it for this hearing, or maybe it's I
May
didn't.
I hand
No,
one
I
up,
haven't.
and then you can see. So it's at page 40 of this bundle.
Sorry. Thank you. Page 40.
Page 40. And you'll see page 44, the request that if the court rejects the argument or overturns the argument on which the Divisional Court found against asylum aid, that it upholds it on different grounds.
Okay, well, I'm not in a position to judge the extent to which that argument makes for a much longer hearing.
Well, I
So
can
it
tell
might.
you, my lord,
You
why
think
it
it
does,
does?
because that argument is the entire argument that was heard below. So the argument below focused on the fairness of the procedure based on the common position between the parties, that fairness required asylum seekers to be able to advance representations on the general safety of Rwanda. In other words, the safety on return of Rwanda as a matter of generality for all asylum seekers. The Secretary of State, that was the common position up until the second day of the hearing. The Secretary of State then reversed her position and the issues narrowed down. But she is now seeking to argue as well the argument which
Yeah,
did
okay,
not...
you have made the
Yes.
point, yes.
So you,
Okay, no,
you will
it's
be-
okay. You've explained to me why it will take 1.5 days,
Yes.
even with pre-reading.
Even with, because you are hearing effectively
Yeah.
without the benefit of a judgment, because the court did not do as it might have done. It did not rule on the issues that were pleaded. It did not say, well, if we're wrong on
No,
this...
no, I promise you I've got the point, Mr. Gilroy.
Well, my lord, I apologise for repeating.
No, I can see it's important to you, and I don't criticise you for
Well, it's
wanting to be
important
sure
to
I
my
got it,
client,
but I
my
have.
lord.
No, I mean, I am clearly going to think again about the estimate, and I will. It's a complicated question. It's not just a question of how long it will take, but to get an appropriate constitution for them means you can't just say, oh, we'll add an extra day or an extra couple of days or whatever it is. And so I will have to look at the plan B and the plan C, which are not ideal, but are not terrible either, because the points are self-contained. Actually, I think you all know from your experience at the bar, sometimes if you're tail end Charlie, you find that some points rather get overlooked. So if Mr. Gill gets permission, he might possibly want a separate hearing. But we'll see. I'm not making any decisions now, and it will require quite careful thought rather than me just sticking my finger in the air.
Well, may I just add on that question? If your lordship looks at the judgment, you'll see that section D is the section that deals with procedural fairness.
Yeah.
It's dealt with separately to all the other issues. The Secretary of State lodged a skeleton argument separately on that issue, and it was obviously heard separately.
Yeah.
Below.
So are you saying that you wouldn't mind being in a separate hearing?
I am, in the light of what your lordship has said. It's not Asylum Aid's primary position, but in the light of the fact that 3 days is what your lordship has said is available in this April hearing, we do suggest that in order to allow us to put these important arguments to the court, it would be preferable, given that we've been heard separately all along, for us to continue to be heard separately. It makes a lot of sense. And I do need to, because
well, there's a slight disadvantage. Yes, all right. I do see that, but it does mean there is an overlap between your points and some of the points being taken by other parties.
Yes.
And they would have to be there, but they'd probably want to be there in case, although they'd allow you to make the running, they might want to add points of their own so that it's less efficient. But it may not be. It'll be perfect because we'll get the right outcome in the end. But it may not be totally neat, and I'm going to have to think what the least bad option is.
I accept that there are a number of ways in which it might be done, but the systemic procedural arguments advanced by Asylum Aid could be separated.
Yeah, I've got that.
Then there may be ways of accommodating some of the individual arguments, of which there aren't that many, alongside that hearing or in one sense, in one way or another. But I do also need to address you on skeleton argument, my lord, because Asylum Aid is also in a different position on the skeleton argument for the reasons I've already set out, which is that we have permission already on all of our grounds. We do not need to serve a replacement skeleton argument as everyone else has offered to do by, I think, the 20th of March.
No, not a replacement. Well, sorry, don't. A very natural use of language, but replacement skeleton argument means something different. You mean
further skeleton, post-permission skeleton argument, call it. We're not in that position.
No.
We are in the position where we don't know what.
Okay, I understand, but you haven't told me yet what you want.
We want the Secretary of State to serve. That skeleton argument was due today.
Yes, I see.
And we would like the Secretary of State to serve her skeleton argument as soon as possible because it will address the respondent's notice. And until we've seen the scope of the argument, both on the original grounds to which the Secretary of State has, on the new grounds to which the Secretary of State has never yet pleaded, there's no written document. We simply don't know what the Secretary of State's position is on our
I got
grounds.
the point. Yeah.
And on the respondent's notice, we cannot put in our full argument. And we have said in our skeleton argument that we reserve the right to seek permission to lodge a skeleton argument if a respondent's notice were served or were lodged. It was lodged, but we can't do anything until we know what the Secretary of State's position is. And there's no reason.
Well, no, I've got the point. Mr. Sheldon, what do you say about that?
Well, my lord, ideally, if this case is going to be heard all in one go, we would put in a single skeleton argument which addressed everything.
Yes.
If Ms. Kilroy is right, and I don't, for present purposes, accept her characterisation, but if she's right, and that the Asylum Aid position is that we're just simply going to be re-arguing the case that was presented before the Divisional Court, well, she has our Divisional Court skeleton argument.
Well, all right, but I think, I'll tell you how I'm thinking about it at the moment. I don't yet know what the shape of the hearing is going to be, and I'm not convinced that the Asylum Aid arguments are wholly self-contained, but they are substantially self-contained, perhaps I can put it that way. And I do see some advantage in the Secretary of State doing a skeleton argument in response to her existing skeleton argument. The primary losers will be the court, who have to look at two skeleton arguments rather than one, but speaking for the court, we'll put up with that. I don't want to put you under undue time pressure, but you're going to have to do it sooner or later. And there might actually be an advantage to you, frankly, in getting this bit under your belt. So how long do you think you would, unless you want to try and persuade me otherwise, how long do you think you would need to do a response to the skeleton argument you've got now?
21 days.
Which will take us up to Yes. 20. Well, Mr. Kilroy, you probably would like it sooner. On the other hand, you've got the substance of what you want. You can try and persuade me to say less than 21 days, but you'll have to try quite hard.
Well, my lord, the rules require a skeleton argument within 14 days of the respondent's notice, which was on the 16th of February.
Well, I can extend them, can't I?
Of course you can, my lord, but there needs to be a good reason, and there isn't one.
Well, as they say they need it, this is an important and difficult case.
Well, they haven't said they need it, they've just asked for it. And there's no basis on which they say they need it. I mean, they've said it.
Mr. Sheldon, why do you need it?
Well, my lord, it's got to be drafted. It has to
Yes, well, I agree. That
it then has to be approved. It then has to go to the Secretary of State for approval. It takes some time to go through the process.
when's Easter?
Easter is the 7th of April.
So yeah, I see. So it'd be yeah. So today's the 6th. So that 21 that would be to the 20. Must be the time of the evening. I can't do my arithmetic. 21 plus 6 is 27th. Yes, even I can do that.
My lord, the problem is that's just before the vacation, and so it puts us at a real disadvantage in considering and responding. And really, if my lord is...
What day of the week is the 27th?
It's a Monday.
And that's the Monday before the week before Easter. I will give you till the noon on the previous Friday, which is the 24th. Which coincidentally is the same date as UNHCR. Sorry, Mr. Kilroy, that's what you're going to get. Anyone else want that? There were some people wanting to do skeleton arguments of more than 25 pages.
My lord, can I just mention something in relation to is there time estimate? I think we're going to need a day. So far as timetabling is concerned, I think there are some advantages in us being heard on a separate day by the same constitution shortly after whatever the main hearing is. But the evidence in the generic bundles, the evidence is all going to be common because there's a lot in that stuff. So that's what I'll say in relation to bundles. In relation to skeleton arguments, because there will be some cross-referencing to materials in the AAA skeletons and bundles and to the asylum aid on the notice and fairness points, I would ask the court, when it says the timetable for skeletons, to give us more than the 20th of whatever it was this month.
Well, you're in a very strong position. You on this, you've drafted your skeleton argument already.
I'm not. I think I can do a better job than that.
Well, you're very modest, Mr. Gill. Since you've invited this, I found it helpful. I found it quite dense at points. So if you were able to make it crisper, then I would certainly welcome you having another go at it. I mean, I'm sure all the points are there, but
I didn't mean that to be critical of anybody. I take responsibility for it.
Oh, okay. Just say no more. But no, look, I note what you say, but the moment, and I'm not going to make any decisions now. But I think your working assumption should be that you are bound by the same timetable as everyone else.
Well, if you tell me, then of course I'm bound by it.
If you get permission at all.
Yes.
I think there's a special reason why asylum aid's in a slightly different position, but I'm not convinced that's so in your case. Anyone else got any submissions on?
My lord.
Yes.
I'm the correct Mr. Vinsky.
Yes, I'm sorry, Mr. Vinsky. I do know you actually, but I was just, there you are. You, and I'm going to have to go in 1 minute. But you want. I think what I indicated, and would confirm, you will certainly get permission to intervene. That goes without saying, and you've got timetable for your written submissions. I am not prepared at this stage, it's not normally my practice, to give an indication on whether or for how long you will get permission to intervene. Get permission to make oral submissions. If nearer the time we can tell you, we will tell you. But these things are often quite unpredictable. And you'll have to prepare on the basis that you can make oral submissions in case we ask for them. But I'm afraid interveners don't have an absolute right. I do understand UNHCR is very central to this case. I'm not in any way putting you down, but I still will want to see actually the points on which you can add value. And that may mean you get half an hour, which I think is all you got below, isn't it? You probably wanted more.
My lord, in fact, we were given an hour in the end. The court invited the parties to give UNHCR more time if they were minded to. The court itself invited UNHCR to keep going. So
yes, well, I dare say you will end up with more, but I don't want to commit myself. It's not from any hostility to UNHCR making oral submissions. It's out of a natural caution about giving you this time, and actually in the end it turns out you need more or less.
My lord,
we will not be unsympathetic to oral submissions.
And may I say, I'm very grateful also for the court's indication that we have permission. Could I say that Mr. Sheldon helpfully has already said to us that the Secretary of State has no objection to UNHCR making oral submissions?
No, and nor have I. It's, I'm repeating myself, it's a question of how long.
Of course.
Now, is there anything else that has to be dealt with now?
Well, can I just say that your Lordship knows our position?
Yes.
We will be putting in a note on Mr. Hussein's Plan B.
Yes.
We do not share his perspective about severance. We regard it as important that the issues are held as one, with a possible exception
about Mr. Gill's point.
Yes. No, well, we certainly positively submit that data protection and possibly my trafficking issue can be severed.
Oh, I see.
And if that means that we are putting everything into a 4-day slot, then that is
I think the way I'm thinking now, for what it's worth, I probably shouldn't say this because I need to think about it more, is that we can probably get a 4-day slot, and I will want to get everything into it that isn't obviously self-contained. And if everyone thinks, oh, that won't give us enough time, I'm afraid you'll just have to cut your coat according to your cloth. Well, advocacy has to be a bit more efficient these days than it used to be. But that's all. That's no more than a preliminary indication. Will you excuse me if I now go? Thank you all for all your help, and I expect to be seeing at least most of you again in April, if not before.